can I say we're not going to talk about contracts or enterprise agreements. They can be boring at times. The fun in employment is the Christmas party. It's the photocopier machine. And it's what happens out of hours, where I think as HR practitioners, as lawyers, we tend to always find ourselves amazed from either what everyone's doing outside of work, or that managers or people in the business get upset or feel threatened or somehow aggrieved by what has happened out of hours. So today, Amber and I are going to look at out of hours conduct. We're going to look at the boundaries. Where are the boundaries? Where do they lie? How do they move? Because I think it's fair to say they're not clear. We're going to look at lots of cases because they're just too interesting to ignore.
And because we love the law.
We love the law, that's right. And there's going to be lots of opportunity for interaction. To begin with, Amber, why is out of hours conduct such a topic of interest these days?
It's a very good question. Actually, let's do a... ultimately, what we know is... I'm just going to use a big, loud voice. I'm a little bit disappointed because I do have my Madonna headset. But given I don't have the conical bra, maybe it won't matter that I'm not using it. In terms of why is this such an interesting topic? It's an interesting topic because of the evolution of what is the workplace. Now, we've got Dolly there. Once upon a time, we used to work 9 to 5 back in the day. Does anybody remember that? Has anybody ever worked 9 to 5? Anyway. Pen and paper, you were home for dinner, there was less social connectivity, less diversity at the pub, lack of permanency, and once upon a time what happened at the pub stayed at the pub. Now we live in a brave new world. Basically, because of the wonders of modern technology, we do live in a 24/7 world. We've got access to email and internet all the time. People are addicted to social media. And so what we are seeing is that there is far more of a blurring between what's happening out of work and what is actually filtering back into the workplace.
So let's start off by seeing what everyone thinks with some modern examples. So if you all hop on, someone's already voted. Should a construction worker be sacked for calling a feminist a derogatory word on Facebook?
Has everybody actually logged into the poll? Because this is actually going to, that little bar is going to...
Go along.
So has everybody had a chance to log in?
And so someone's going to sack this poor construction worker who over the weekend and in his own time just decided to express some views to a feminist. Yep.
So the overwhelming answer at the moment is no.
Sorry, a feminist he doesn't work with.
Doesn't work with, that's right.
Doesn't work with, yep. Okay, so everyone wouldn't. So free to be derogatory on the weekend if you're a construction worker.
Now,
okay.
But what about should a professional worker be sacked for assaulting their partner at home? Yes! All right.
Well, we're all taking a tough stand and we're stepping into the home and the privacy of a relationship. No, we've got one no. Don't know. Well, you probably don't know because it's quite tough. Because domestic violence is abhorrent and you want to take a stand, but it's a private relationship. Quite tough. Let's go to the next poll. You're a government liaison officer, and should you be dismissed for publicly supporting pro-abortion laws when the government is against it?
50-50.
Oh, right. Oh, okay.
Yes.
Oh, yeah.
Next. No. Yes.
So do we all take the view you're entitled to your opinion? Yep. By and large. Don't care about the job of the person? Okay.
What about Should an apprentice, I'm going to insert an extra word here, should an apprentice butcher be dismissed after being charged, it's true life, after being charged with accessory to murder?
Oh, so many knives.
When you say charged, is he actually found?
Very
Not
good
yet.
question.
Not guilty yet.
Just charged.
Just charged.
Very good question from the crowd.
Does it matter if the murder involved a knife? No? I'm pretty sure they operate sharp knives in butcheries. So
Does he have access to it?
all of this is based on real recent cases. So Armadale Butcher was involved in an unfair dismissal suit because the butcher sacked him after he was charged with being an accessory to a murder charge. Cricket Australia sacked their government liaison officer for tweeting that the Tasmanian government should do certain things in the area of abortion, when during the day she would be responsible for liaising with that government. Now, correct me if I'm wrong, Amber, that case settled. It was going to be tested on the basis that under the Fair Work Act she had a right to a political opinion and she was dismissed for expressing the political opinion. Another case recently was a health worker who supports domestic violence victims is sacked after admitting to assaulting their partner. The feminist comment, it was Clementine Ford, wrote an article about white ribbon, and Michael Nolan wrote one word, SLUT, on Facebook in response to the article. 2 days later, Clementine Ford had searched his web pages or his social media pages, found out where he worked, linked it to that comment. On Tuesday, it was on the front page of the Daily Telegraph, Meriton sacks Michael Nolan. So these are real live issues. And for Meriton, the issue was that they were a supporter of white ribbon. And someone's writing an article about it and he writes a very derogatory word. Now, he didn't bring an unfair dismissal claim. He was probably a knockabout sort of bloke and took it as a notch on his belt, a bit of fame, running through. He never brought it, but that would have been a real interesting case as to how far can the law go. But employment's a lot more than just unfair dismissal. Got to say that up front. There's other laws, safety, discrimination, workers' compensation. So let's examine out-of-hours conduct through those different prisms.
But given everybody loves a poll, let's keep going. Ready? Can you dismiss an employee for sexually harassing or assaulting a work colleague out of hours in employer-provided accommodation? Resounding yes at the moment. Okay. Pretty categorical response there.
Hit refresh. No?
Going to the next one, but that's all right.
No?
Are we having technical difficulties?
Yep. Okay, hands up. Would you sack?
Yes.
Yes? Yep. All
Excellent.
believe? Okay, overwhelming.
Thanks, everyone.
Good. Is an employer liable for an employee's sexual harassment of another employee after hours when it's in employer-provided accommodation?
Some nodding.
It's working.
It's working again, everyone.
Okay. So we're all liable for it.
All right, what about this one? Is a worker entitled to workers' compensation for injury sustained in employer-provided accommodation during sexual activity? Oh, we're not
Boy.
sure. Maybe yes,
Really?
maybe no. No, yes, yes, no.
Should at least be a medal for it. How vigorous was the activity?
Right.
Well, all right.
All right. So, As James said, what is interesting about this issue is that we do have a whole bunch of intersecting obligations as employers. So on the one hand, we have unfair dismissal laws. We also have discrimination and sexual harassment laws. We have work health and safety legislation. We have workers' compensation legislation. So there are a whole myriad of obligations which are going to inform what our appropriate response is to any of this particular conduct, but also what our exposure or liability is. So what I was just going to do is step through a few particular decisions which show, having regard to which jurisdiction you might find yourself in, that it appears sometimes that we're getting different answers about what we should do about particular things. This particular case, now I'm going to flag first up that it's a 1999 decision, and I would suggest that probably today, if heard again, there'd be a different result. So, and we can chat about that in case I'm being controversial. But basically this was a circumstance where a flight attendant was dismissed as a consequence of sexually harassing another member of staff in a hotel room, but it happened during a break. So flight attendants fly into a particular port, clock off, and then the next day clock back on again, and this happened in that intervening period. Now this particular person was dismissed, brought an unfair dismissal claim, and it was decided that that wasn't a valid reason for dismissal because this happened in that person's own personal time. Now I say that today the same decision I expect would deliver a different result because increasingly what we are seeing is obviously this blurring, but ultimately if something happens out of hours has the capacity to impact on relationships and ability to effectively work together within work hours, that then starts having a relevant connection with the workplace, even though it may have been during clock off time.
Would you go straight to dismissal, or should there be some other form of disciplinary action before dismissal in these circumstances?
Would you go straight to dismissal? First of all, obviously you'd have to go through a process, so that requires procedural fairness, so that's another thing to be thinking about when we're in the unfair dismissal jurisdiction. Various elements of the claim. One is whether there's a valid reason, another is whether somebody has been afforded procedural fairness. But then what we also know is, as a general overlay, when we're looking at the unfair dismissal jurisdiction, was it harsh or unjust or unreasonable in the particular circumstances? So there are a number of considerations that need to inform the decision. Do I think that sexually harassing a member of staff in a hotel room is not a valid reason for dismissal? No. No. I think that is a valid reason for dismissal. This particular case, South Pacific Resort Hotels and Trainer, hands up if you've never heard of this case. I thought so, not many people. So this is basically one of those cases that started to test the boundaries for the purposes of sexual harassment under the Sex Discrimination Act, started to test the boundaries about what was conduct in the course of employment or conduct related to employment. And as James noted, what's interesting when you cut across the different pieces of legislation is that there are different phrases that are used, so that's a relevant consideration as a lawyer. In any event, what this was all about was that this was a particular island resort. Everybody was provided with staffies accommodation, and there were rules about staffies accommodation, and that was that you weren't supposed to have your mates from work back in your room. Like this was your accommodation that you're provided as part of your work because you're in this remote location. In any event, one particular staff member entered another staff member's room and engaged in sexual harassment. And the question that arose was, well, that was outside of work hours. Was there a sufficient connection with the workplace? And the answer was yes. The answer was yes because it was the working relationship that had facilitated the contact, that it was the employer who provided that accommodation, so it was part and parcel of the job, and so therefore the nexus with the workplace was actually met.
sometimes you have Christmas parties. We know your Christmas party's coming up. If anything goes wrong at the Christmas party, employer's liable. But then employees kick on and go somewhere different, and it breaks
Yes.
the disconnect. Under South Pacific's resorts, would an employer be liable for any conduct that occurs at the disco?
At the
Afterwards.
disco.
Afterwards.
I love it. He's
Isn't
my
that what
age.
they're still called? Sorry.
The disco. Look, I keep coming back to this, that, and this is a really tricky one for employers, particularly around Christmas party season. So what we are seeing is that employers are trying to put parameters around what is the work-sponsored event versus the kick-on at the disco. And so often part of the delineation will be our event finishes at 10 o'clock, or our bar tab finishes at 10 o'clock, or this is our venue for the Christmas party, so if you're at a different venue, the connection has been broken. And the reality is there are no neat lines, because we keep coming back to the issue of, does something that happened out of the workplace have the capacity to impact on relationships within the workplace? What did you talk about, Comcare?
Comcare, okay. Well, I suppose in one sense you might say this is the odd one out, or perhaps the one that makes more sense. Employee involved in vigorous sexual activity, bumps her head on the light above the bed head. How?
The hotel
Don't know.
bed.
Don't know. Anyway, seeks workers' compensation on the basis that it was an injury that occurred in the course of employment, and received it. And we had to go to the High Court.
Just as a factual footnote, so the context was that she was on a work conference. So she was in the hotel room as a consequence of being at this work conference.
Which the employer paid for.
Which the employer paid for. So she basically said, on this particular occasion, when I was engaging in vigorous exercise, it was still really part of my working day because I was on a work conference.
And the High Court said, quite sensibly, I don't think it was in the course of your employment because I don't understand your employer asked you to engage in vigorous sex in the break. Now, apply that in its simplicity. I don't think South Pacific Resorts asked the worker to sexually harass other workers after hours in the accommodation. So you sort of wonder, is there a disconnect? Because all of those cases and all of those surveys you answered all involved employer-provided accommodation. Why is it different?
So as I mentioned, what we're looking at is different legislative obligations or different areas of exposure for employers, but different obligations to your employee. So as I said from the outset, if we're looking at this through the lens of an unfair dismissal claim, what we're looking at is valid reason, was the person afforded procedural fairness, would the outcome be harsh in all of the circumstances? When we're looking at sexual harassment, there are different considerations that come into play. So first up is, does the conduct constitute sexual harassment? But there's also this important issue for the purpose of sexual harassment, which is the employer liable for that particular conduct? So what we know is, for the purposes of the legislation, an employer will be vicariously liable for the conduct of that naughty employee unless the employer can demonstrate that it took all reasonable steps to prevent that conduct. So what that means is, when you're dealing with a sexual harassment claim, there are one or two things that an employer can do. It can basically embrace the employee, bring them in and defend the claim, or it can basically be cutting the employee loose and say, well, hang on a second, we're not liable for that conduct because we trained you on what was appropriate conduct. We had in place policies. We made it clear that that was never going to be acceptable in our workplace, and if you engage in that conduct, we're not liable because we did everything to try and avoid it. Then we've got workers' compensation legislation. Hands up, I'm not a workers' compensation expert, thankfully. It's a whole new universe. But the test there is basically whether somebody suffered an injury in the course of the person's employment. And now we're laughing about the High Court case, but it took
Quite a bit.
quite a bit.
Yeah.
There were a few decisions along the way. And then obviously what we all know as well is, for the purposes of the work health and safety legislation, we have an obligation to provide a safe place of work while workers are at work. So what is at work? And it's a rubbery concept.
Yeah, and they're different prisms. You know, in one sense, one's about providing compensation in respect of injuries in connection with the work, but everything else, well, that's someone else's responsibility and liability. Sexual harassment is more about protecting in a bit more of a broader sense from particular behaviour. And unfair dismissal, there's a little bit of need to protect an employee's privacy. I want you to think of this situation. 2 men walk into a pub. 2 men walk out of the pub. They go to their employer-provided hotel. They're in the same room and they punch on.
Is that kind of like disco?
No, punch on. Fight. Fisticuffs. Employees dismissed. That's the framework for which we now look at whether an employer can take action in respect of an employee's out-of-hours conduct. At the time they punched on, no one was wearing the company's uniform. It wasn't in a public place. And what the Commission said, now President Ross of the Fair Work Commission said, is that in certain circumstances, so they're trying to create some boundary, an employee's employment may be validly terminated because of out-of-hours conduct, but those circumstances are limited. And they protect that boundary quite jealously. The conduct must be that, viewed objectively, it is likely to cause serious damage. Serious damage. Not some tension, not some uneasiness, serious damage to the relationship between the employer and employee. The conduct damages the employer's interests. Or the conduct is incompatible with the employee's duty as an employee. So in this case, punch up in a hotel room between 2 blokes who probably forgot about it the next day, wasn't serious damage to the relationship of employment that existed with Telstra. Didn't damage Telstra's reputation because they weren't wearing the uniform. It was in the hotel room. No one saw it. There was no evidence that it led to any public backlash. And it occurred out of hours, so there was no incompatibility with these 2 men being able to do their jobs otherwise. There was no evidence of that. But what's missing there is that the Commission's not looking at, well, what's the impact between the relationship between the 2 employees? Or perhaps between the employee that punched on and was the provoker with other employees who perhaps are aware of the incident. There's another principle that's important.
There is. So you can see that one there. And this is what the court had to say. Mindful that caution should be exercised when an extension is made to private activities, it needs to be carefully contained and needs to be fully justified. But once an employee's conduct can be shown to have significant and adverse effects in the workplace because of its impact on workplace relations, on the productivity of others, or on the effective conduct of the employer's business, the conduct becomes a proper matter of legitimate concern to an employer and does so of its consequences. So the point is, and it's really a point that I was making earlier, is what you're looking at is, does something that happened outside of the workplace have the capacity to impact on functioning of relationships and the business back in the workplace? And this was a slightly interesting one, this case, and you'll see again, this is a 1996 case, so it's an early decision. But this was a case where an employer became aware of the fact that there was a degree of sexual harassment going on outside of the workplace, and so made a direction to a staff member to stop engaging in that conduct outside of the workplace. And then what happened was the employee did not comply with that direction and was sacked. And this was actually run as a judicial review, administrative decisions review decision. So it was in a different realm. But this is basically the principle that emerged. And even though it's a 1996 principle, this is still really the guiding principle around the intersection.
And it's great law, particularly when we have a look at the epidemic we've got at the moment to do with bullying and how readily complaints of bullying are made and how readily they come into the workplace. Miss Borker received nasty text messages from, Facebook messages, posts on Facebook made on Saturday and Sunday by colleagues who happen to be union delegates or union representatives. And she brought a bullying application. And the defence of the union, kid me not, was we posted it on Saturday, you can't get us, it's not at work. And building on McManus, what the full bench said it doesn't matter when you make the posts. It's the fact that when you get there on Monday and you open up Facebook and there's this nasty post about you, the bullying occurs at work. Doesn't matter that the post is on Saturday, because all the hardship and grief that one feels from a nasty derogatory post is with them when they turn up to work on Monday. The difficulty in the relationship is there on Monday. So when you come to bullying, you can see how easy it is for what is nasty and what shouldn't happen in human interactions that might occur on the weekend can readily be brought into the workplace and be a legitimate concern for the employer. Now let's deal quickly with the butcher.
This is the butcher case. So this is one that we mentioned during our poll. So this was a circumstance where there was the young apprentice butcher. He was charged with accessory to murder. The employer became aware of it because the employee's mum called to say that he couldn't come to work the next day because he was in custody, proceeded to explain what had happened, and then the owner of the butchery told his mum that he was sacked. So there are a few problems with process there in terms of how that all played out. But ultimately, this was in the context of a small town. The employer said, look, I have other employees who don't want to work with this guy because now they're frightened, because they said that in the days leading up to this particular incident, when he was sharpening his knives, he was angry. So they were a bit frightened. And then what the butcher was also concerned about was that the impact this was going to have on the business in a small community, to have this gentleman there who had been named in the newspaper, and he was the one who worked at the butcher. Now, ultimately, in this particular decision, there are a number of procedural flaws which probably could result in there being a different outcome, but fundamentally, the issue is always going to be, when there is any measure of criminal conduct, does it have genuine relevance to the workplace? The question that we had right from the get-go around the difference between charges and conviction is a very important distinction. And so this is, we often have that situation where somebody will say, this person's been or even convicted of a PCA offence. Can we sack them? It's like, well, what do they do? Well, they're a receptionist. I wouldn't have thought so. What's the connection between what happened over here and over there? Say, for example, you have an employee who is convicted of fraud and they're your CFO. Well, that would obviously be a different outcome. But so criminal conduct, what happens outside the workplace can be very relevant to what happens in terms of that person's employment in the workplace. But there needs to be a connection, a relevant connection.
I always think of the phone call I got from a funeral place where they get all the bodies ready, and the beautician or the person that does the work had been charged with bestiality and really couldn't have them working in the funeral parlour. It would have made the business go out. In the end, it was a complete wrong charge, completely acquitted, but the damage was done that they just could never work there again, even acquitted. The minds of the community were poisoned, so to speak. Now, I want you to consider you're the manager in a business, you've been promoted, you've got someone under you who is difficult, but you're managing them, and another colleague comes running to you and says, oh, there's a Facebook post. I've got a Facebook post here that the underling's written. How much of the bosses did you suck to get where you are? Is that about you? Do you sack them? Yep.
That's
Yep.
the
Sack them,
spirit.
sack
Yeah.
them, sack them. Oh, people. No. How do you know it was about you? The worker said it was a post they wrote in support of their mum who was having difficulties at her work. Okay? Yeah, probably our suspicious minds think it's about us. But it's the target's not clear. The target's not clear, so the connection to work isn't clear.
James, do you kind of think that's like the time that I had a particular matter involving a gentleman, loose term, who'd sent a particular photo of a particular appendage, and then when he was pulled up on it said, oh, I didn't mean to send you that photo. I think implausible explanation. That's what I think.
So, well, the explanation was it was in support of his mother who was having difficulties at work.
Of course it was.
And it was believed. But it's a good point. Don't get too sensitive. Is it clear? Is it about you? Don't jump to conclusions.
And if it was clear?
Absolutely. Can't think of anything more derogatory to say to someone who's just been promoted that they only got there because of sexualised activity, behaviours. Amber.
Magic hand. Okay, this is an interesting decision. So this involved a person who had been a lawyer at Legal Aid New South Wales for some 30 years and apparently was an impeccable lawyer, very good at his job, no performance issues whatsoever, no disciplinary issues. However, he was charged and then also convicted of domestic violence offences. And the employer became aware of it and they sacked him. And they sacked him in part because part of Legal Aid's remit is helping vulnerable people in the community. It's about assisting victims of domestic violence, and indeed it's a very big part of their charter. But on the other hand, this was a guy whose role was as a lawyer. He was a great lawyer, he got great results, and his position was, this was an aberration, I did a really stupid thing, you've got to let me off the hook. Commission said, no, absolutely a valid reason for dismissal. There is the sufficient connection with the role that he is performing. As a footnote, I'll mention, because I was chatting to Stephen from Corrective Services, quite a different result a number of years ago in an unfair dismissal decision, also down at the New South Wales Industrial Relations Commission, involving a Corrective Services officer, so to use the vernacular, a screw, who had been charged with, and convicted as I understand it, various domestic violence offences. So the first time it happened, he was given a warning. The second time it happened, it kind of unfortunately got lost in translation. The third time it happened, he got sacked. and the Industrial Relations Commission reinstated him. So that was a decision that preceded Sandilands, and I believe that part of what we are seeing in the evolution of these decisions is also the evolution of community standards and expectations. And I think that the public-private divide, and certainly in the context of domestic violence, it's not a private issue, it is assault. And I think we are seeing a real evolution.
Yeah, that's right. Though that line is probably going to be tested as we move along. You think about the construction worker, you know, is his activities towards his partner in his private time relevant to his work? Probably not. But what tips it over that in similar facts, circumstances, you could be justified dismissing the construction worker? It may be that the employer has a corporate social responsibility program and is a big supporter of white ribbon. Or it may be that the courts move to where they take a moral stand. But I think that line's going to be jealously guarded for many years to come.
Yes.
In Sandilands, wasn't also part of the problem, the remorse was not seen as genuine because he was still contesting the conviction. So it's not that he said, it's one off, I'm really sorry. It's he said, I might be sorry for the purpose of these proceedings, but it didn't really happen.
I think that's a really fair call. And part of it as well was, I think he was downplaying the significance of the actual interaction. So for people who aren't familiar with the case, it was he assaulted his wife and his daughter actually witnessed the whole incident, and it got to the point where he was actually choking her. It was a very, from the descriptions, a very intense assault. And I think part of it was, I think that's a really fair observation, he sort of was downplaying it a little bit and probably wasn't demonstrating a significant level of remorse. I think that's a very fair call.
Now, Mr. Stussel demonstrated remorse.
Oh, Mr. Stussel. Again, I'm sounding like a broken down record. This is a 2012 decision and I don't think you'd get the same result at the moment. But this was a circumstance where I keep using the expression gentleman, and I don't know why I do, because these people aren't. Really offensive remarks. Posted him on Facebook, comments about particular people, really yucky stuff. And he was sacked because the employer said, don't want that in our workplace, really unsavoury behaviour, not acceptable. Now, they were on Facebook, right? And he was an older gentleman, a mature gentleman. And he said, look, I didn't understand Facebook. My daughter set it up for me. I thought I was having a private conversation. I didn't realise that other people would be able to have access to that. Yeah, look, sorry about that. Had I known that other people would be able to see it, I wouldn't have done the same thing. And that defence was accepted. And why I say that you couldn't expect that response now is that I think everybody knows now that social media is not private. It's not the water cooler conversation. So I think there would be a different outcome.
So to just even the scales, Miss Belevins was a childcare worker, had issues with Kitty Corp, her employer underpaying her, engaged a lawyer to represent her, was exercising her workplace rights in New Zealand, and the employer walked out of a negotiation, put a post on Facebook saying, I don't believe the way Kitty Corp treats their people, their employees, it's terrible, and I hope they don't treat the children that way. Miss Belevins, in her own time, away from work, liked that comment. Miss Belevins was friends with a lot of the parents at the childcare centre. Connection to work easily established. Given we've just had the midterms, let's talk about freedom of speech.
Do we think, I guess the answer's there. I was going to say, do we think that there is a general freedom of speech in Australia? But the answer's there, so spoiler alert. No, there's not. There is a limited implied freedom of political communication to protect the free expression of political opinion as an indispensable part of a representative and responsible government. So, what happens when somebody expresses a strong view which they suggest is expressing their particular political opinion. So have a look at that for a moment. Mr. Gaynor had this to say on
Twitter.
Facebook,
Yeah, Twitter.
and this was in the context of the marriage equality debate.
Correct.
Yes. Next slide, please. What do we know about Mr. Gaynor?
No, we're going to ask Ken.
Thank you.
Can you, on Twitter, express the views about whether or not... No, you can't. Yes, you can.
All right. Oh, yes, no, yes, no.
Okay. So a lot of people think you can't express views on a topic which is a topic of conversation in the community. No, we're even. 50-50.
Let's throw in a few facts and see if it changes anybody's view. So, first up, Mr. Gaynor was employed by the Australian Defence Force. And his Twitter feed readily identified him as an employee of the Australian Defence Force. Operating in tandem, he had political aspirations, and I think he was going to run
He was running for Senate.
So on the one hand, he was using his Twitter feed as a device to be building his political career, but at the same time, he was seeking to, draw on the legitimacy of him as a candidate as being an employee of the Australian Defence Force. So this is my credibility. So the two were intertwined. So that was Mr. Gaynor's journey. At the same time, the Australian Defence Force was actually going through a lot of cultural awareness training and cultural training programs because they were trying to change a lot of the attitudes, a lot of the problems that had been identified in the Australian Defence Force, particularly you might remember a number of years ago around sexual harassment and all manner of horrible things that were happening. So it was certainly the case that at that particular time, that particular employer was very focused on inclusiveness, making everybody feel comfortable in the workplace, making sure that they were promoting a workplace that was free from discrimination and harassment. As part of what the Australian Defence Force was doing, they had a policy on social media which provided defence personnel must not post material that is offensive towards any group or person based on any personal traits, attributes, beliefs or practices that exploit, objectify or are derogatory of gender, ethnicity or religion. Pretty clear statement on what its expectations were. His posts, we've seen them. So the ADF becomes aware of them, and what do? First of all, what they asked him to do was de-identify the posts. What I should say is de-identify himself as an ADF employee. So what they didn't say to him is, you can't say that. What they did say to him is, if you want to say that, we want you to decouple that from your employment with us, because our concern is that those could be interpreted as views of our particular organisation. What did Mr. Gaynor do in response to that particular direction? He ignored it. He said, no, I'm not doing that. And then what did the Department of Defence do? I think they gave him another warning before then moving to terminate him. So there was a process that they had been through. So then what Mr. Gaynor did was that he commenced proceedings against the ADF. Now, what they had done was exercise a power to terminate under the Public Service Act, which was about whether somebody's employment was in the interests of the Australian Defence Force. What he argued was that the termination infringed his right of political expression. What the Australian Defence Force said was, we didn't tell you not to express your political opinion. What we told you to do was not connect it with your employment with us. And ultimately, the Defence Force was successful. Now, that was a really smart way for them to deal with the issue, obviously. Another relevant consideration was, not surprisingly, the Australian Defence Force is a command and control structure. If in a time of war you are told to do something, it's incumbent upon you to do something. That's inherent in the role of being a part of the Australian Defence Force. And so that was seen to be relevant as well, his failure to comply with a direction. Interesting case.
Yeah, and it's not the only case out there at present dealing with activity on social media and expressing political opinions, and it's going to be a real hotbed of issues, particularly in the environment we're in at the moment where everyone's got a view on everything and everything's up in the air. Miss Benjury is the case that keeps giving. Commonwealth public servant, relatively senior but not in the upper echelons. Has a Twitter handle, so that's the Twitter name, LA Legal. Do not know it's her. Do not know it's her at all. She's a prolific tweeter, more than 9,000 tweets over the period we're talking about. But she comments on matters relevant to the portfolio she's working, relevant to immigration. So comments about the organisation, the business. Bitter, abusive tweets about the government, linking Julia Gillard and Craig Thompson was one of the tweets. But only one tweet happened during working hours. There was a lot of analysis, but only one during working hours. So by and large, all of them are outside hours. Now, immigration were getting upset with this Twitter feed because of what was being said, that the secret squirrels went in and discovered it was her. Okay, so you're never really anonymous, but she was. They found out. She admitted it when confronted and offered an unreserved apology for her conduct. Then she must have started searching on the internet and read about freedom of speech and everything, and withdrew her confession and apology. And so the drama began. She made an application to prevent her dismissal. She ended up being dismissed. The dismissal caused her to suffer an adjustment disorder. So she brought a workers' comp claim. First instance, to prevent the dismissal, Federal Circuit Court said, and she brought it under lots of grounds, including the Fair Work Act has a protection. You can't be treated adversely if you exercise or make a political opinion. And what the Federal Circuit Court said, even if there is a constitutional right or the rights for which you talk about, it doesn't give you a licence to breach your employment contract. Duty of good faith and fidelity, confidentiality and the like. Step forward. 5 years. 5 years. This year, she says, I suffered an adjustment disorder from being terminated. The employer, Comcare, who runs it from the insurance point of view, said, no, it was reasonable management action. She says, well, it can't be reasonable management action because I've got an implied right to communicate about political matters. The Administrative Decisions Tribunal, amazing decisions tribunal sometimes, said the act of termination trespassed on it, so therefore it follows the termination was unlawful, and ipso facto, throw in some Latin, cannot be reasonable administrative action. Now, the reasoning is as follows. There's a limited right to communicate about political matters, and immigration, unfortunately, everything you talk about in that area is political and there's political opinions. But if her comments were open, if we knew it was from her, the employee, then it's okay to discipline. And you wouldn't be impairing the freedom. But because it was anonymous, then you do minimal damage to immigration, therefore you can't, and it doesn't make sense. It doesn't make sense that my way of thinking is if it's anonymous, you're dishonest. You're dishonest about breaching confidentiality. You're dishonest about using information you've got in your employment. Now, I've put up there off to the High Court in 2019 because very rarely does the Attorney General use his or her powers to go straight to the High Court. Forget going to the Federal Court and the full Federal Court, straight to the High Court. And the High Court's going to hear this next year to work out whether or not such tweets are, and dismissal for such tweets, more importantly, is reasonable management action. I would have thought it was. So that's off to the High Court. So let's wrap this up and just some really quick tips. Have a policy. Do not be afraid to tell people that they're going to be good people outside of work. And do not be afraid to warn them that, guess what, if you do something bad on the weekend, it may be in the Telegraph on Monday, it may come back to us and we may be concerned. I think everyone's a little bit naive. The word privacy gets thrown around too much. The ease at which things come into work is amazing. When we're dealing with the issue, I think we've got to ask ourselves, has the employee's actions come into the workplace? If you're talking to a manager and you say, oh, how did you find out about it? And they say, oh, look, I was just snooping around on their Facebook page, you're already in a lot of trouble as an employer. But if it's come into the workplace, then you're on a bit of a stronger foundation to say, this is a concern for us because it's come to us. We haven't gone out looking for it. I think you've always got to assess the effects of the conduct, and you've got to look at it a little bit critically. Has the employee's actions and consequences had significant and adverse effects for the business and the workplace? And add to that, in working relationships with others, with their colleagues. Has it had a significant and adverse effect or the potential to do so? Because sometimes the sleeper issues become the bigger issues later on. The next assessment is the more senior you are, I think the more restraint you've got to exercise. You can sort of forgive an underling or a low-level worker doing the wrong thing, making the wrong comment on social media, being a little bit naive. But the higher you are, the more of a guardian you are, the more client-facing you are, there's got to be more restraint. And I think that's really important when you're assessing the conduct. What did I expect of this employee? What can I legitimately have expected from them on the weekend because of their position and duties?
Should we talk about the Goodall dilemma? Just as a postscript, because I do think this is an interesting thing to think about as employers. The standard you walk past is the standard you accept. What sort of culture do you want to promote in your particular organisation? This particular case, the Goodall decision, involved a member of staff who had used social media to make some absolutely deplorable comments about his colleagues. There were Islamophobic comments, there were homophobic comments. It was really quite disgusting and insidious behaviour. And the employer took decisive action to remove him from the workplace because they didn't want that in their workplace. So that was their view of the culture that they were trying to promote. Unfair dismissal, he was successful, he was reinstated. And the employer said, this is outrageous, we are going to appeal this decision. And in an extraordinary turn of events, the full bench affirmed the original decision because they found there wasn't a basis to intervene in the decision. However, the dissenting judgment, I think, is the key takeaway message from the particular case, and certainly the position that I do think employers should be considering, and that is this. Mount Arthur took decisive action to eliminate Islamophobia and homophobia in its workplace. It should have been commended for its actions, not punished by being required to take Mr Goodall back. And I think ultimately it's a message that employers need to consider, is that it's often the case that there will be this balance of, well, what's the risk if I take particular action? What are the consequences for me as a business? Versus, well, what do I want to achieve? What sort of workplace do I want to have? Now, this is an example where the legal decision did actually create exposure for that particular employer, but I think in the eyes of the public, it took the right action, and employers should be commended for that.
And I think that really ties into our last point, because a lot of out-of-hours conduct at the moment is going to be controversial. And whilst we're going to try not to be oversensitive, and we're going to try not to be the moral police as employers, we are the guardians of our organisation's reputation and values. And sometimes we're going to need to take a stand for what the organisation stands for. And that might be because of your corporate social responsibility, but also because you want to know what type of employer you are. Compassionate, proportionate and firm. A lot of the cases we spoke about, McManus and others, there were warnings before about the out-of-hour conduct to cease. But if you give those warnings, maybe you've got to be firm and protect your values, your reputation, even if the line is blurred or may not be in your favour. Any questions?
Just a quick follow-up,
Yep.
James, on that case that you were mentioning where it's going to the High Court.
Yes.
In the second decision, the AAT, is that a decision that's come about because of the workers' compensation claim of that employer?
Correct. It's a workers' compensation claim, and the employer was running the defence that there was a psychological injury and there's no compensation for psychological injuries if they occur as a result of reasonable management action.
So does that in a way go back to the point Amber was making at the beginning around different statutory tests?
Correct, it does, but you've got a federal circuit court that said we're not going to stop the dismissal because your behaviour doesn't justify you breaching the contract. So the Department of Immigration dismissed, and they followed a fair process. But then you've got, in another context, saying it's not reasonable management action because you're protected in making those tweets. In other words, you can do it. In other words, you do have a licence to anonymously attack your employer and the government you're serving. That's why it's going to the High Court, because there is that disconnect.
Thank you.
It's probably not a question, just more of a comment for someone who works in the media. The interesting thing about that ADF case, and they asked him to de-identify being an ADF. If one of our senior journalists de-identified themselves, you'd still all know they were a journalist.
Yeah.
So we've actually got a different test in our
Yeah,
business.
that makes a lot of sense.
Yeah. And you certainly got to be conscious of the fact that you might not identify yourself, but you can be found out. So I'm certainly aware of a case of applications on the internet that can use photos and they scan and then they identify where you appear, and that could very readily link you to your employer. So you'd really want to do a lot to be off the grid, but be on the grid.
What falls under political? I wouldn't have thought homosexuality would fall under a political commentary.
It's a political debate at present.
It's a good question though, Clem. So there is certainly scope to say that it wasn't a political statement, but for the fact, as James said, that in the context, which was during the marriage equality debate, unfortunately, it was being treated as a political hot potato and it was being treated as a political issue. But yeah, I mean, certainly that comment in a different context may have made it more difficult for him to say, well, this is my political commentary. It's a fair call.
But a lot's political these days. A lot is. And people are going to be throwing it up and testing it, such as the Cricket Australia case. That would have been front and centre, but for a swift settlement.
But there's no clear definition of what falls under political.
No.
Well, thank you, everybody.
The Cricket Australia?
Yeah, the weakness for the employee was the nature of a role, being a doctor or a crane driver or something else. The views would be irrelevant given the key part of the role was to maintain a good relationship with the government.
Spot on.
Yep.
Yeah, you're absolutely right.
And that's the incompatibility with the employee's duty or duties. Thank you very much.
Thank you, everyone.
May you all have a safe and enjoyable Christmas.